In the next few hours after this sojourn ceremony, I will remove my wig and this gold-striped black gown. I will hang them in the wardrobe. I will have worn them for the last time. They have been my faithful companions in this court since the first time I put them on 13 years ago. Now, it is time for them to take a deserved rest. The wig and gown will join their companions, the purple-striped black gown that I had last worn as the judges of the Court of Appeal 13 years ago. The gold-striped black gown of the Supreme Court and the purple-striped black gown of the Court of Appeal will join the plain silk black gown that I wore for the last time as a judge of the High Court of Oyo State in November 2005. There is yet another gown in my wardrobe. That is the barrister's gown, and I wore as an advocate of the Supreme Court of Nigeria when I was called to the bar exactly 43 years ago and 1 month. The gowns, whether they are gold-striped, purple-striped, or plain black, are more than gowns. For someone who hailed from Iseyin, the town of weavers, I can say that the gowns are the tapestry with which my professional and judicial career is woven. They represent important milestones in my life. They had the chapters in the autobiography of my life. They had the signpost on the journey of my road to where we are today. What a journey it has been. I am thankful to the previous distinguished speakers who have been kind with their words about me in their speeches. They have all been most generous in their narrative of our relationship and our interactions. I thank you all. Your Excellencies, my Lords, Your Royal Highnesses and Royal Majesties, distinguished ladies and gentlemen, in our nation, Yoruba Kingdom, in fact, in most parts of Africa, before literacy was introduced, one way of marking a significant date was to tie it with a momentous event that occurred around the same time. You have been told, even though the Honorable Attorney General skipped it, that I was born in 1954. That is 70 years ago. What you have not been told is that the year I was born was the same year the Littleton Constitution of 1954 was promulgated. It was that constitution that established the Federal Supreme Court of Nigeria, the same institution it had pleased Almighty Allah for me to head. The Supreme Court is therefore more than a court to me. The Supreme Court is my pathmate. The court is 70 years old this year, the same as my humble self. I was therefore born in the same year the Supreme Court was established. What I'm not certain of is whether when I was born in Iseyin, my parents, Alhaji Shitu Ariwoola Makwala, Papa Eleko Lebedi, and my mother, Alhaja Mistura Ayuade Ariwoola, ever knew that their newborn baby will have anything to do with the important court that was established in Lagos that same year. Therefore, I look back today with a heart full of gratitude. As an elementary pupil in local authority demonstration school, Oluwole Iseyin, then headed by Chief Mrs. Oke, one regular assignment we were usually given in English language lessons was to be asked to write about a day you will never forget in your life. If I were to be given the same assignment today, distinguished ladies and gentlemen, today, the 22nd August 2024, will certainly be the winner. Today is the culmination of an academic and professional career that started, as I have mentioned earlier, at the LA Demonstration School in 1960, the year Nigerian gained her independence. That was the school where my educational foundation was laid. It was in that school that I learned one of the most important lessons of my life, the habit of punctuality. Many of the previous speakers have alluded to the fact that punctuality appeared to be a way of life for me. What they might not know was that this virtue was inculcated in me from my primary school days. As fate will have it, in all the three institutions I attended prior to the university, I was appointed or elected the timekeeper or the bell prefect. Punctuality was, however, not the only thing I took away from the elementary school. Today, I will reveal the secret of my walking stick to you, which is another manifestation of the grace of Almighty God in my life. It was in primary school that I learned to ride bicycle. One day, during the Salah festival, I was asked to deliver meat to a family. I rode a bicycle for the errand. I had delivered the message and was on my way back home when I had an accident on the bike. Like a stone shot from a catapult, I flew off the bicycle and landed on the ground. For many months, I was hospitalized at the Baptist Hospital in Shaki on account of a broken femur. The white doctors at a point even considered an amputation of the leg. To the glory of God, I walked out of the hospital on my two legs, though on crutches. Notwithstanding that I was in the hospital for months, I did not miss any academic session. I went to write my exams from the hospital bed. I graduated with my classmates. However, the pain in my left leg came back in 1970 when I was already in Ansarudin High School, Shaki. I was soon back in the same Baptist hospital where Dr. Fatula, an Ekiti man, performed the miracle that finally healed the leg. As it happened, my father had a lawyer who was representing him in litigation whenever he was involved in. The lawyer was dashing, smart, and brilliant. He was Prince Stephen Lauyi Popola and was always smartly dressed, and his spoken English was impeccable. He had this infectious confidence around him. Instantly, I knew I wanted to be like him. When I was in Form 2, my father asked me one day what I wanted to study at the university, and my answer was straightforward: law. The journey to study law was, however, not that straightforward. There was a detour to Obokun Advanced Studies Center in Ilesha, where I spent 2 years preparing for my HSC before finally getting to my destination, the University of Ife, Ile-Ife, the most beautiful campus in Africa, Great Ife. At Ife, I was trained by a world-class faculty, including the renowned Professor David Ijalaye, a Professor Emeritus of Law, Professor Ise Sage, Professor Gabriel Olawoyin, and Professor Retuyi, among others. My LLB degree was not the I have succeeded in not dropping the bat in this regard as I hand it over to the KMO. We are all witnesses to the fact that I came to the office as the Chief Justice of Nigeria at a critical point in the history of both our nation and our judiciary. Our country was in the process of political transition, and our judiciary was in a state of turmoil. The task appeared daunting, and the challenges appeared insurmountable. However, With our faith in God and our trust in Him solidly for guidance, our ship was able to successfully navigate the seemingly perilous waves and bat safely at the harbor of peace. I must pay sincere and heartfelt tributes to my brother justices of this court, whom I have the privilege to sit with here. They are true brothers indeed, and in fact, it must be realized that a Chief Justice is not the boss or the employer of his brother justices. Not at all. He is not. He is only the first among equals. A Chief Justice must therefore not see himself as the emperor of the Supreme Court. The occupier must work with his colleagues with mutual respect in order to have a successful administration. One of the first things we did on the assumption of office was democratizing the working of the court. We created committees of the justices. We had a litigation committee, the administration committee, a welfare committee, a finance and budget committee, and of course, other committees, all headed by justice of the court. With this in place, I was then able to focus on the duty of administering the court. Although this innovative system is not codified, it has been a successful experiment, and I hope other courts will consider it too. My noble lords, it is my conviction that the right to fair hearing enshrined in the Constitution of the Federal Republic of Nigeria could only be meaningful when litigants have enough judges and justices to hear their cases. Justice is not a scarce commodity to be queued for. Justice without delay is inherent, natural, and constitutional. In my view, it is antithetical to the concept of justice when litigants are made to wait for years in order to have their cases determined. As a justice of the Supreme Court, it was always a sobering moment for me whenever an appeal was called to be heard and a learned counsel stood up to inform the court that the appellant or the respondent was late. He had died. In effect, the litigant had died without his appeal being determined one way or the other. It was for this reason that I made it a priority, with the support of God, that no stone must be left unturned to ensure that we brought more judicial officers into the system. I must express our collective gratitude to the distinguished members of the Federal Judicial Service Commission and the National Judicial Council for their commitment to the project of liberalization of the judiciary. Without their active participation, we could not have pushed the process through. The legislative arm of government must also be commended, not only for the swift constitutional screening of the nominees where required, but also for the budgetary approval required to fund the appointment. The executive arm deserves commendation for the political will to see the project to the end. In this regard, we have all succeeded in demonstrating the practical working of the constitutional principle of separation of powers. The three arms of government are separate but not disparate. We are independent but not in isolation. We cooperate but we do not compromise. This, in my view, is the true essence of separation of powers. With the departure of His Lordship Justice Amina Ogi in September 2023, the Supreme Court was left with only 10 of us. It was the lot of the 10 of us to wade through the tons and tons of political, criminal, and civil cases that were filed in the Supreme Court. At this point, it will be invidious of me if I fail to commend my 9 brother justices who were with me at this critical point. There was a justice who was so ill that His Lordship was always sitting with a face mask throughout the period. Yet, His Lordship could not afford to be off work, even for a week. I am very grateful to you all for this sacrifice. It is gratifying that Nigerians have indeed recognized your selfless and patriotic service to the nation. Through your judgments, you have restored the confidence of Nigerians in the judiciary. By your decisions, you have given hope to the common man. With your pronouncement, my lords, you have shown that we are not a court of law, but a court of justice and equity. This is our duty as the Supreme Court. I thank you all. The Supreme Court was not the only court that benefited from the appointment of new judges and judges. The bench of the Court of Appeal also had its rank swelled by the appointment of 2 sets of new justices in 2023 and 2024. With respect to the trial courts, that is the Federal High Court and National Industrial Court, the High Court of the Federal Capital Territory, and the High Court of States, they all experience injection of new judges. This will go a long way in facilitating speedy dispensation of justice. My noble lords, it is, however, my belief that access to justice should not be regarded as uncontrolled and unfiltered liberty to bring all forms of cases to the Supreme Court. It is my belief that we trivialize the institution of the Supreme Court as a court of policy when every form of litigation is able to meander its way to the apex court. It also diminishes the judicial importance of the Court of Appeal, that very important appellate court, when every one of its decisions must be reviewed by us here. I dare say that if there is another court that is superior to Supreme Court, many cases will find their way to that court ad infinitum. Counsel and litigants all to know when to call it a day. 11 months ago, Justice Amina Ogi, that extremely brilliant and hardworking jurist, in our valedictory speech, had narrated our surprise that one of the cases that found its way to the Supreme Court was an appeal in respect of 12 goats. Yes, 12 goats were the subject of a matter that came to the apex court. What this type of cases do is to clog the system, thereby depriving other important cases from being heard. For the record, for the 2022 and 2023 legal year, from the 12th day of September 2022 to the 11th day of July 2023, 1,271 matters were filed at the Supreme Court. This comprised motions and appeals. Out of this number, we had 388 political appeals, 215 criminal appeals, and 464 civil appeals. We also considered a total number of 153 civil motions, 49 criminal motions, and of course, 2 political motions. Between 30th day of September 2022 and the 11th day of July 2023, the court delivered a total of 251 judgments. Out of these, 125 were political appeals, 81 were civil appeals, and 45 were criminal appeals. Within the same period of 10 months, a total of 91 rulings were delivered by this court. The 2023 and 2024 legal year commenced in September 2023, and by the time the curtain was drawn over the year in July 2024, a total of 1,124 cases were filed in it. Out of these, 435 were civil cases and 269 were civil motions. 219 criminal cases were filed within the same period, and 102 criminal motions were filed. Notwithstanding that the year was not technically an election year, 86 political appeals back at this apex court. The last category was originating summons cases, which were 10 in number. Within the same period, we delivered a total of 247 judgments and rulings, with civil and originating summons cases having 92 judgments, criminal appeals having 81 judgments, and 74 judgments delivered in respect of political appeals. My lords, it is crystal clear from the foregoing that something needs to be done to ensure that the Supreme Court is not unduly overburdened. It was in order to address the judicial porosity that the National Judicial Institute collaborated with the Federal Ministry of Justice and the Nigerian Bar Association under the leadership of distinguished Mikhail SAN to host the Justice Sector Reform Summit in April. The summit made far-reaching decisions which will greatly assist the justice sector delivery in our country. There will be a big gap in this address if I do not mention the fact that the Supreme Court Mediation Center, which was established during the tenure of my Lord the Honorable Justice Mahmoud Mohammed, GCON, CJN, their clients, will take advantage of the center to ensure that their matters are resolved speedily and harmoniously without the attendant friction of litigation. One area where we have also attempted to make a difference is in the aspect of the welfare of judicial officers, both serving and retired. A judicial officer's work is not from 9 a.m. to 5 p.m. The reality of our existence is that a judge's job is a 24-hour job. He sits in the court from 9 a.m. to about 3 p.m., if not later. When others close for the day, a judicial officer resumes his afternoon shift. That is when he begins to prepare his judgments and rulings. When others are resting at home after dinner, he commences his night shift by reading his files for the next day. There is no judge worth his salt that will not read his files before getting to the court. For the past 32 years, I have always had one judgment or ruling pending for me to write. I cannot recall a single time in the last 3 decades when there was no judgment for me to write. I am glad to see my younger brother Ademola Abbas Ariwoola seated here now with us this morning. He has been based in the United States since his undergraduate days in the early 80s. Anytime I had traveled to visit him for vacation, his wife would always exclaim that she had never seen someone coming on vacation with records of appeals and briefs of argument for writing judgment. It is for this reason that I believe that emoluments of judicial officers must not be sweated for in or outside the office. Our judges must not be made to go cap in hand to beg before their remunerations is paid. Our retired justices deserve to live in a relative reasonable comfort after spending their prime years serving the country. This is more so that they are constitutionally precluded from going back to active practice as barristers after leaving office. If truth must be told, the welfare of the judiciary is the welfare of the country. I am glad that we have made appreciable progress in this regard with the passage of the bill for an act to prescribe the salaries, allowances, and fringe benefits of judicial officers, office holders in Nigeria, and for related matters by the National Assembly. It is also for this reason that we have instituted the Judicial Assistant Scheme for our justices in the Supreme Court. One peculiar feature of the work of a judicial officer is that his performance is not delegable. It is not an assignment that can be done by proxy. A brother judge cannot prepare your judgment for you. He cannot conduct your trial for you. He cannot assess your witnesses for you. It is thus a back-breaking profession. We thus instituted the idea of judicial assistant to provide relief for justices in the area of research and documentation. This crop of staff will aid the work of their lordships by conducting research for them. It is hoped that the scheme will be a permanent feature of our justice system at all levels. When I became the Chief Justice of Nigeria, I was concerned about the fact that the rules regulating procedures in the Apex Court were those made 39 years ago. Although practice directions have been issued at regular intervals over the years, to meet demands of justice. The substantive rules were still as made in 1985. I am convinced that the rules of procedure of any court are the engine that drives its operation. It is also my view that the rules must be dynamic and contemporary in order to meet the changing demands of both the bench and the bar. At the time the Supreme Court rules 1985 were made, things that are now ubiquitous, like information technology, electronic transactions, and global telecommunications, among others, were either not in existence or in their formative infancy. How then could such obsolete rules be adequate for the challenges of today? It was for this reason that I empaneled the Rules Committee to undertake the arduous assignment of reviewing the 39-year-old rules and the many extant practice directions comprehensively. I'm glad to report to you all that earlier this month, pursuant to the provisions of Section 236 of the Constitution of the Federal Republic of Nigeria, 1999, I signed off on the new Supreme Court Rules 2024. In this regard, I must not fail to commend the wonderful job done by His Lordship's, the Honorable Justice Kudirat Kekere-Ekun, JSC, Justice Nyango Koro, JSC, Justice Marom Keji Elin Ogunmeju, JSC, Justice Tijani Abubakar, JSC, Dr. Muiz Banire, SAN, and Makayao Yakubu, SAN. Their dedication and commitment ensured that the new rules became a reality. I'm indeed very grateful to them. There is this executive summary of the new rules. The Supreme Court Rules 2024 has repealed the Supreme Court Rules of 1985 and has crystallized all the existing relevant rules and practice directions into one body of rules for easy access by the court and legal practitioners who practice in this court. The Rules Committee, which, as I said, was chaired by Honorable Justice Kudirat Kekere-Ekun. Other members, as I said, are Johnny Yangokoro, JSC, Ogunwumeju, JSC, Tijana Abubakar, JSC, and the immediate past president, who is also outgoing like me, Honorable Makayao, and Dr. Muiz Banire. The Rules Committee's secretariat comprised of Ibrahim Gold, Esquire, Yusuf Babastoro, Esquire, Saadatu Ahmed, Esquire, Zainab Garba Mohammed, Esquire, and Patricia Ohomuru, Esquire. These all are well appreciated for their dedication and commitment to the work. The new Supreme Court rules have the following highlights, if you care. Extension of the hours when the registry will be open and the formal introduction of a comprehensive e-filing system, the introduction of the service of most processes by electronic means, the virtual hearing protocols have also been set out in detail. The electronic case scheduling and management system will be put in place. In the near future, a Nigerian case management system, NCMS, e-filing portal will be available to counsel and the court. More duties have been imposed on the bar to aid the speedy hearing of appeals, where service is effected on a legal practitioner who has ceased to appear for any party. Failure to inform the court expeditiously will be deemed an act of professional misconduct. Service on the Attorney General of the Federation or an Attorney General of a state is deemed sufficient service where the federal or state government of Nigeria is a party. Parties are now mandated to file notice of non-contention when they do not intend to contest an application. Most applications for leave shall be heard in chambers pursuant to Section 233, subsection 3 of the 99 Constitution as amended. One of the most important innovations in these rules is the execution of the policy to reduce the volume of applications for extension of time which have been abused over the years. Now, time provided by the rules is automatically extended for the same period in the first instance. It is also further extended for same period provided with the payment of penalty in default, and no application for extension of time shall be entertained thereafter except in an appeal against a death penalty. This simply means that if you have 7 days to file a process, if you do not do so, you have another 7 days automatically so to do the needful. After the cumulative 14 days, you have another 7 days, in which case you will pay penalty for default within that third 7 days. After 21 days, there is more extension of time. Importantly, no application will be entertained by this court. The time to file briefs have been reduced. A section of the registry has been created to manage electronic processes, including the electronic copies of the record of appeal. It is now mandatory for the appellant in this court to pay costs awarded by the court below into an escrow account. To ensure diligence in appeals against monetary judgments, the court will require a guarantee of or bond from a reliable and reputable financial institution as a condition to hear the appeal. Where the appeal relates to land, an undertaking to pay damages where the appeal fails, this court will not grant stay of proceedings in an interlocutory appeal brought before it. Where the appeal fails to comply with the conditions of appeal, this court will so move to dismiss the appeal. With regards to costs, the court will now adequately award costs to compensate the respondent for the time and expense in coming to court. Also, where counsel engages in an abuse of the process of the Supreme Court, punitive costs will be awarded personally against such counsel, including a counsel representing the federal or state government on an institution or representing an institution. Counsel who fails to pay costs awarded personally shall not have right of audience in any superior court in Nigeria. There are provisions made to fast-track criminal appeals relating to terrorism, rape, kidnapping, money laundering, corruption, and human trafficking. The procedure in election matters have been elevated and incorporated into the rules with enhanced guidelines to ensure speedy dispensation of justice. Learned senior advocates may appear with not more than 5 learned friends. Where more than one senior advocate appears in a matter, the total number of counsel shall not be more than 8 for the party. That is the executive summary of the 2024 rule that you will soon have on your hand. As a youngster, I was an avid reader. Avid. The taste in reading was eclectic. I read every novel I came across, but judicial responsibilities, however, had made me to cut down drastically on reading non-legal works. Now that I am retiring, I believe and I intend to commence reading without the pressure of pending judgments or rulings. One of the novels I had read long time ago was by James Hadley Chase with the title, There is Always a Price Tag. I mentioned above the fact that Court of Appeal justices are nomadic justices by virtue of our frequent posting. What I did not mention then is that that some people are always paying the price for our absence from home. That is our family. I must therefore not end this address without paying tribute to the forbearance of my family during the same year, begged and inserted in my chest to serve as a passage for the blood. It was testing time for me and family, but glory be to God. I'm today alive to witness this crowning moment of my career. I'm grateful to Justice Sulaiman Galadima, DSC, retired, who took it upon himself to request the Chief Imam of the Supreme Court Mosque to continue to supplicate for me while the surgery lasted. My friends, Dr. Junaidu Gudina and Dr. Moshood Sodiq in Ibadan, were also engaged in prayers throughout the time I was in the theater. I am grateful to them all. I must not end this address without expressing my appreciation to the staff of all the courts I had been privileged to sit. I remember with nostalgia practitioners who are just coming to the profession. It is your responsibility to hold their hand during their formative years. This is one of your most important duties. As a fruit does not fall far from the tree, so the younger lawyers are seen as a reflection of their seniors. Of recent, we have started witnessing a fall, not only in the standard of advocacy, but also in the manner of the dressing of young lawyers and our colleagues. It is important to reiterate the elementary point that it is highly unprofessional for counsel to address court in the second person as you. It must always be the court, or your lordship, or my lord. Respect and decorum between the bench and the bar is the foundation of our profession. I will say no more on this issue. I preface this speech with a tale of my 4 gowns. They are gowns that will become relics of my personal museum. They are gowns that I am not entitled to wear again by virtue of the provisions of Section 2911 of the 99 Constitution of the Federal Republic of Nigeria. By that referenced provision, it is mandatory for me to cease to be a judicial officer by midnight of today. However, I have another gown that I'm entitled to wear as a statutory right. Earlier this year, I was appointed the vice chairman of the body of benchers, the body of legal practitioners of the highest distinction. I have been a bencher since I joined the Supreme Court in 2011. A couple of years ago, I became a live bencher. I cannot thank Almighty God enough for all these mercies shown to the boy from Ishain. I am forever grateful to him. Your Excellencies, my noble lords, distinguished ladies and gentlemen, one striking feature of existence is time. It is one asset we have that is constant but is not static. It's always on the move. It is any wonder that chapter 103 of the Noble Quran is titled The Passage of Time. A veritable gentleman tells us that he understood the meaning of this chapter of the Quran from a nice vendor who was shouting in the market, "Oh people, have mercy on one whose assets are melting away. Time is therefore life, and to everything we do, there is time for it. Otherwise, the time will melt away like ice. The time has now come for me to take a deserved rest. I acknowledge the greatness of God in my life for his manifold favors. Which of the favors of God will I deny? I pray for the repose of the souls of my great-grandfather, Olukayode Ariwoola, and that of my grandfather, Abdulsalam. I pray for forgiveness for my parents, Alhaji Shitu Ariwoola and Alhaja Mistura Ariwoola. They gave us their best. May Allah expand their grace for them. The Ariwoola family of Ishain, many thanks for being there for me. I am grateful to the good people of Ishain Town, Okeogun community, and Oyo State. Kábíyèsí Ọba His Royal Majesty, the Olawale Oyebola III,